Hi everyone, I'm Jennifer McDonald of the law firm of Jennifer McDonald. I am coming to you today from my office. I am a divorce and family law attorney, so I do a lot of child custody, divorces, and other things that are related, so grandparent visitation and parenting time, that sort of thing. I wanted to talk to you today a little bit about what exactly happens in a divorce process. So I'm going to give you a very simple timeline. This is something that I do in my initial consultation, so if you come in and meet with me, I will probably give you a very similar spiel on how the divorce process works. The benefit of coming in for an initial consultation is that you can stop me anywhere along the line and we can answer questions, go through sort of how this process would work for you specifically, because obviously each case is a little bit different and each case has its own unique pieces. So I can't tell you exactly what's going to go on in your case today because you are not sitting here in my office. But if you come in for a consultation, I can do that with you. What we're going to do today is just do a very simple timeline of how the process works in Colorado. Each county is a little bit different, but they all sort of follow the same guidelines. So to start with, what the court does is you file your initial petition for dissolution of marriage. So right here at the beginning, we've got petition for dissolution of marriage. What that means is you file and ask the court for a divorce. So you take your paperwork, you give the court basically all of your contact information, your address, your phone number, email, that kind of thing, birth dates, social security numbers. We file your petition for dissolution of marriage. If you and your spouse are in agreement about getting divorced, then we file a joint petition. Otherwise, you will have to file your petition and then serve the other party. So you send them the petition and you send them a summons. Summons tells them, hey, you are being asked to come to the court. Somebody has filed a divorce case against you. If we have to serve the other person, we can talk about whether you want to do it nice, whether you want them to see if we can get them to sign a waiver of service, or if you want to just go ahead and serve them, kind of like in the movies, we send somebody out to their house, or we can send someone to their office and just hand them the paperwork. Once they are served, then this starts your timeline. So along the timeline, the court will then start setting you for hearings. Right at the beginning, they set you for what's called an initial status conference. Initial status conference usually happens within 42 days of the petition being filed. So within 42 days of you filing a petition, you will have this hearing with a judge. If you have an attorney, you will have a judge. Otherwise, if you file without an attorney, you may go in front of someone called a family court facilitator. That's like a clerk at the courthouse who sets up hearings and that sort of thing. But if you have an attorney, it's very likely that you will go in front of a judge or a magistrate. This initial status conference is just a quick, probably 15 or 20-minute meeting with the judge where they tell you sort of how the court process works and what the requirements are for getting divorced. And it's basically their chance to meet you and see what's going on. This makes a lot of people really nervous. It's your first court appearance. As an attorney, not a ton happens that day except for the setting of calendaring deadlines and calendaring hearings, that sort of thing. If you have an immediate issue, this is the time to say to the judge, I really need some child support, I really need some maintenance, I'm not seeing my kids at all, I need parenting time orders. And if that happens, you can tell them at the initial status conference and they'll start setting you for other hearings. Other hearings that the judge can set you for are temporary orders. So if you have one of those immediate issues, the judge can set you for a temporary orders hearing. Or if you don't have any immediate issues, what courts are tending to do right now is to just ask the parties to go to mediation and then let the court know after mediation whether or not the case is going to settle before they set it for a hearing. What the judge wants you to do at mediation. So mediation is very likely to happen either before temporary orders or after temporary orders before you go to a permanent orders hearing. I think every court in Colorado probably will require that you go to mediation unless for some reason there's domestic violence that would make mediation unsuccessful. But most judges will require mediation because mediation is the court's attempt to force you to settle amicably. So the court always has the goal of getting you and your ex-spouse to settle your case in a way that works the best for you. And it's always better to try and settle your case because if you can settle, you're choosing for yourself what your life is going to be like versus letting a judge who doesn't know you very well, sees you for 2 hours, letting them decide what your life is going to be. So if you can settle your case, it's always something I encourage, and the courts actually encourage it too by making you go to mediation. So before you go to any hearing, you will have mediation. And please excuse my terrible handwriting, but mediation is either here or here. What the court is also going to do from the time you file your petition, in the state of Colorado, you have a statutory waiting period before you can actually get divorced. So you won't be allowed to be divorced until the 92nd day, and it's actually 91 days, but The statute says that you have to file the petition from the date of service, so from the date that you either have your ex-spouse sign a waiver of service or get served. 91 days from then you are eligible to be divorced. So before that you have to wait. On the 92nd day, if you and your spouse have written up an agreement and everything is settled and you're ready to be done, you filed all the paperwork, the judge can look at your paperwork on the 92nd day and you can be divorced. Otherwise your divorce will happen after that. So if you write everything up, you can be done on the 92nd day. If you agree then shortly very after at the mediation, right before temporary orders, you can be done right after that. Or you have a chance to settle after temporary orders. You have a chance to settle all the way up until permanent orders. So sometimes people will settle right before the end of their case, right before the hearing, but they just decide to choose for themselves what they want to do. So if you can't settle your case, then we're going to get all the way out here to a permanent orders hearing. What permanent orders is your opportunity to present your entire case. So we get all of your financial disclosures, we get everything put together, and the judge will then hear your case at permanent orders. The attorneys will present evidence, which means they'll call witnesses to the stand. You get to say, all the bad things you want to say about your spouse, and they get to say all the bad things about you. You talk about your financials, you talk about your children, you talk about everything at permanent orders. Judges are now setting those hearings for either half day or full day. Sometimes you only get 2 hours. So you'll really only get maybe a max of 6 hours in front of a judge, both sides, to present your entire life to the judge. And then at the end of that hearing, they will decide for you how things are going to be divided, how the parenting time is going to be. So I'm great in court. I'm really good at taking you to permanent orders. I'm happy. I love doing it. It's fun for me. That's why I'm a lawyer. But I would love to settle your case before we get to permanent orders hearing, just because two parents sitting in a hearing against each other and saying the most horrible things they can about each other is not a good way to start off on the right foot being co-parents. If you can avoid that permanent orders hearing, that I prefer that. But if we have to do it, we have to do it. Sometimes, the other side just won't come to an agreement, and that's okay too. Something I did mention is your financial disclosure. So at this 42nd day at the initial status conference, if they're not done already, the court is going to require that you do 16.2 disclosures. I call them Rule 16.2 disclosures. That's the statute where you find the requirement for the financial disclosures. What Rule 16.2 disclosures means is the court requires you and your opposing party to give a full financial disclosure. So all your tax returns for the last 3 years, pay stubs, all your bank accounts, all your retirement accounts. We need a full picture of what's going on financially in your marriage. Some marriages, people don't actually share that information with each other, so the court's trying to force you to do that through your divorce. So even if you've got bank accounts that the other side doesn't know about, you're supposed to give them to the other side. I will require you to give them to the other side. You're not allowed to hide anything from my office. I take these financial disclosures really seriously. This is the basis of your financial case. So we get all of that financial information, and then what I do with it is I put it into an Excel spreadsheet. So I put in, here are all your assets, your house, your bank accounts, your retirement accounts. I put everything in there, and then we kind of figure out who gets it. So in the state of Colorado, it's a court of equity, which means that it has to be equitable, which is fair. It doesn't have to be equal. So we don't take the house and split it in half, the retirements and split it. We don't split it in half down the middle. What I like to do is do what I think is a little bit easier. And some people would disagree with me on that, but what is easier, I think, is, if one person gets the house and the other person gets other assets, we try to equal it out so that sometimes it's fair, and sometimes it's if what is in one person's name versus the other person's name isn't fair, we can do an equalization payment, or maybe we transfer a retirement account to the other person. It really depends a lot on your case, and we have to do really, really good full financial disclosures to determine how that sort of sorts itself out. For the financial piece of the case, I do want you to do your disclosures, and then we just kind of have to see how it goes from there to see what is going to be fair. That's sort of the financial piece of your case. A second piece of the financial disclosures is that we do disclosures, really good disclosures on what your income is. So income is used to determine what the maintenance and the child support will be in your case. So if you have children, child support is usually an issue. And as far as maintenance, so maintenance is the new word for alimony in the state of Colorado. So what we do is if you've been married at least 3 years, we have to run a calculation. So the statutes have guidelines in them of what a judge has to do as far as maintenance. So if you've been married at least 3 years, the judge puts into a calculator your income, your spouse's income, and they just kind of run the numbers of what the maintenance could be or should be according to the guidelines. Now, the judge doesn't have to follow the guidelines, but it's very likely that they are going to, just because the statutes do have those outlined in there. But if you can present a good case of why the maintenance shouldn't be that way, or why it should be a little bit different, if you have a lot of other financial requirements of you that you just don't think you can pay maintenance, then we just go through those issues and we try and outline them for the judge of why you shouldn't have to pay maintenance. But again, we do have to look at the guideline amounts, run the worksheet and see what the guidelines would say, and then determine whether or not that's an appropriate number for you. And then same with child support, there's the same calculator. We put your income in, your spouse's income in, the number of overnights that each of you have for parenting time, and then it gives us a number as far as what child support should be. Now, the benefit of hiring an attorney is that we can play with those numbers a little bit and putting in, what you pay for health care and that sort of thing. So it's always good to come and talk to an attorney about what your maintenance and child support obligations may be in any case. Now, the other big piece of divorce is usually children. So parenting time and decision making for your children in Colorado, those are the two pieces of what we call custody. So we don't really talk about legal custody anymore. We talk about parenting time and decision making. As far as parenting time and decision making go, parenting time is obviously how much time you get to spend with your children versus how much time your spouse spends with your children. And then decision making is major decision making over medical, extracurricular activities, and education. Those are the three big ones. And then if you have specific things that you think you and your ex-spouse are going to have a hard time talking about, we can also put those things into your decision making, but the judge has the right to make orders about parenting time and decision making. So again, we encourage you go to mediation and talk about those things to come up with something that's going to work for you and your ex-spouse and your family so that you can be the best co-parents that you can be. So those are all things that we talk about all the way along the line. We talk about them at mediation. And then if we can't come to a settlement, we do go to a permanent orders hearing, and you have to discuss all of those issues with the judge. So it's kind of a lot. It's your whole life. It's a lot of things to talk about all on one day at a hearing. So we try as much as we can to sort of make settlements along the way, and or make sure that we know that we have good backup for all of the arguments that you want to make at court if we do have to get to a permanent orders hearing. I used to tell people that this whole process would take at least a year. I think in some counties that's still probably true, but in other counties they are trying to get you to go to mediation and then determine whether you do need a hearing or not, and sometimes they can get you in for a hearing a little bit quicker than that. These days, a couple of the counties, Arapahoe and Douglas, are doing that now. They're changing their process a little bit, but depending on how much you fight and depending on how many issues come up, this can be quite a process. It can take a couple of months, at least 92 days. It can take up to a year. I've had cases who take a lot longer than that, and then obviously after permanent orders, there's a little bit of wrapping up of moving retirement accounts around or selling houses, that sort of thing. So it's always really important to talk to an attorney about your different options and how the process will work for you and your specific circumstances. So please give me a call if you have any questions about this. If you have any questions, you're welcome to post them in the comments, and I'm happy to answer them for you, maybe in a new blog post later. But if you have specific questions about your case, give me a call. I would love to set you up for an initial consultation so we can talk about your situation. Thank you so much. Have a good day.